Ryan Reynolds here from Mint Mobile. With the price of just about everything going up during inflation, we thought we'd bring our prices down. So to help us, we brought in a reverse auctioneer, which is apparently a thing.
Mint Mobile Unlimited Premium Wireless. How to get 30, 30, bit to get 30, bit to get 20, 20, 20, bit to get 20, 20, bit to get 15, 15, 15, 15, just $15 a month? Sold!
Give it a try at mintmobile.com/switch.
$45 upfront payment equivalent to $15 per month. New customers on first 3-month plan only. Taxes and fees extra. Speed slower above 40 gigabytes. See detail.
This episode is brought to you by LifeLock. The holidays mean more travel, more shopping, more time online, and more personal info in places that could expose you to identity theft. That's why LifeLock monitors millions of data points every second. If your identity is stolen, their US-based restoration specialist will fix it, guaranteed or your money back. Get more holiday fun and less holiday worry with LifeLock. Save up to 40% your first year. Visit LifeLock.com/podcast. Terms apply.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined by Ken, a professor of law at Chase Law School. Ken, welcome to this supporters exclusive Week Constitution show.
Yeah, it's great to be back.
It's always a lot of fun doing this. As a matter of fact, we have learned many of our listeners say that the absolute best midweek show is our midweek show. And I think that's because we've continued to just continue. We have not stopped in the face of multiple adversity. Here we are in the 14th Amendment. This is, I think, our third show in the 14th Amendment. And this is going to be our final show in the 4th Amendment. So either you're going to be happy or sad. I don't know. But it is that time of year where, you get things done and then students are supposed to perform. So this is all the fun of, the con law class at the undergraduate and the graduate level with none of the final exams, right? That's what we're doing today.
Yes.
So Ken, this week, what we're taking a look at in the 14th Amendment is what is oftentimes known as the state action doctrine. And this is something that doesn't come up, I think, as much. Some of the portions of the 14th Amendment we've talked about in terms of like the popular conception, because I don't want to say it's not as detailed as some of the things that we've covered, but it is a little unique. It's not sexy exactly in that sense, precisely. Well, the kind of the setup for this is that the 14th Amendment does not interfere with private interactions between individuals. So the 14th Amendment is not supposed to kind of penetrate what you call the sphere of personal freedom, right? Instead, it's supposed to deal with specifically state action. But what makes that kind of complicated, and we've already talked about some of those complications here on the show. Excuse me. We've already talked about some of those complications here on the show. Is that what that means then is if you're a plaintiff, if you're bringing a case, you've got to demonstrate that a state government was either directly responsible or was so significantly involved in the action that is causing harm. So, for example, what if a government official is enforcing a discriminatory covenant among homeowners? Or what about a state-funded school district that's going to have some policies about race, right? So is that enough state action? And so there's a lot of cases. I'm going to save the cases for you because I have learned, if anything, I'm good at setting this up and understanding. But you know the most arcane cases, which I love. It's a lot of fun. But this leads to you have and say, okay, well, is there some kind of public function being happened by this institution? I know we have case law that deals with that. Or the entanglement doctrine, right? Is there so much government operation involved in it that it's going to count as being a state action? And again, as I understand it, Ken, kind of the beginning of really thinking about this in the modern sense begins in 48 with Shelley versus Kramer. And am I right about that?
Yeah, although I wouldn't distinguish as sharply between the modern and the earlier.
Okay.
Yeah. So
Well, see, and that's why you're here. That's why you're here.
Yeah, I think it's right that Shelley versus Kramer really reinvigorated the state action doctrine, or maybe pointed to some ways to work around it. But that was partly because the earlier iterations of it were a little harder to work around. And so the most famous early case, and really the first case in this doctrine, was actually 5 cases, and they're collectively called the civil rights cases. So the civil rights cases is a kind of collective name that the Supreme Court itself gave these 5 cases in 1883. And I'll just talk about one of the 5, but they all raise similar issues. But the one from New York City is the most fun to talk about. It involves Edwin Booth, whose brother was John Wilkes Booth. And you know who John Wilkes Booth was, of course.
Okay. I'm not familiar with this case. I'm going to be honest.
Yeah. You remember John Wilkes Booth's profession? You remember what he did for a living?
Oh, this is a great Jeopardy question. And no, I'm blanking at the moment.
He was a very noted actor of his day, a stage actor.
Yes. Okay. Yeah. Yes.
Okay. Yeah. So John Wilkes Booth came from a whole family. The Booth family as a whole were all noted celebrity stage actors, and they were all also fanatical racists and segregationists, just like John Wilkes Booth was. And so his brother Edwin Booth shared all those characteristics with him. He was a very celebrated actor. He was a fanatical racist. And what happened was after the Civil War ended, and after John Wilkes Booth had assassinated President Abraham Lincoln, and then eventually been caught and convicted, Congress passed the first civil rights legislation in the wake of the Civil War. And Congress had passed different civil rights acts as early as 1866, which is before we even had the 14th Amendment. And then there were some questions about whether Congress had the power to pass civil rights law. And that was one of the things that led to the move to ratify the 14th Amendment, to give Congress the power to enact some civil rights law. And then Congress enacted additional civil rights statutes in 1868, 1871, and 1875. Well, the civil rights cases involved the fourth and final of those statutes, the Civil Rights Act of 1875. And this was a statute that looked in a lot of ways like the Civil Rights Act that we're much more familiar with from nearly 100 years later, the Civil Rights Act of 1964. So a lot of the things that were in the Civil Rights Act of 1964 were also in the Civil Rights Act of 1875. And so among those things were there was a law that said any business that is willing to open itself up to the general public generally, to do business with any customer from the general public, that business is not allowed to discriminate based on race against customers. And the statute specifically named hotels, theaters, places of public amusement as the kinds of places that are open to the public and that can't discriminate based on race.
And that's a really big deal, because that's something that will then later come up, because it's not going to end up standing. I mean, I think people, I hope, recognize that. Yep. That does not become the case, is why we have like hotel cases in the 1950s and 60s. But continue, Ken.
Yeah, exactly. It doesn't end up standing because of the state action doctrine we're talking about. So what happens is Edwin Booth, he although he was from the South like his brother John Wilkes was, he was a famous enough actor that a lot of times he worked on Broadway in New York City, and he was a popular actor on Broadway. And so, but he would always say to all the theaters, look, if I see even one African American, and I'm sure he wouldn't use that word.
That's not the terminology that was being used. That's not the terminology would be.
Yeah, no, if I see even one of them in the audience, I'm walking off the stage. I will not perform for those people. And the theaters that he performed at generally knuckled under and said, "Okay, that's fine." They weren't generally
it's shocking.
segregated.
It's Reconstruction, right? Like, I mean, I think sometimes we have whitewashed that portion of American history pretty significantly, and I think there is this kind of, I think, disconnect. Okay, the Civil War ends, and pretty quickly everything is fine. Yeah. That is kind of, I think, often the narrative. But that's a great point, right? It's probably not so much that a lot of these places are having to go. It's more of, Of course.
Yeah, right. Yeah, I mean, I think not all the theaters in New York were generally segregated all the time, although some of them probably were. But in Booth's case, he made this a condition, and they're all like, "That's fine." It's like Van Halen saying, "Take the red M&Ms out of my M&Ms" or something like that. Just like one of his conditions at the time. And so he he
wasn't ready for that, Ken. I was not ready.
Yeah. It's like I'm a performer.
I would like to point out that it was Ken Katkin who compared black people to red M&Ms.
Yeah, well, just the way he dictated to the theater what the conditions were, and they're like, "That's fine, whatever
yeah,
we want."
No, yes, exactly.
So he won't perform. Well, anyhow, some African Americans and some of their friends who were white decided that they were going to try to enforce the recently enacted Civil Rights Act of 1875. So some white people went to the theater box office and bought tickets. And then once they got the tickets, they handed them to their African-American friends, and the African-American friends show up with the tickets, a few days later, and end up, being told, "Well, no, we can't seat you here because we're not letting, it's white only." And then they complained to the federal authorities, and the federal authorities enforced the law. And so that theater got prosecuted for violating the Civil Rights Act. And so that's one of the 5 cases that came up in 5 different states that are collectively called the civil rights cases. Well, when it gets up to the U.S. Supreme Court in 1883, the theater argues that the Civil Rights Act of 1875, which they violated, is unconstitutional, because the argument is that Congress only has the power to enforce the 14th Amendment. The Section 5 power that Congress gets in the 14th Amendment is a power to enforce the 14th Amendment. And the theater argues that the 14th Amendment only runs against state governments and doesn't run against the private sector. So therefore, if Congress is trying to regulate the private sector, Congress is doing something different than enforcing the 14th Amendment, because the 14th Amendment doesn't run against the private sector. And the Supreme Court agrees with that argument. And the Supreme Court finds that because the 3 words that begin the 14th Amendment are "no state shall," right? So it says no state shall violate the equal protection of the laws. No state shall deprive any person of life, liberty, or property without due process of law. No state shall deprive any citizen of the privileges and immunities of citizens of several states. They're all the antecedent for all those clauses is the words "no state shall."
It is very similar, as we've talked earlier in the show, about most of the earlier Bill of Rights, where it's Congress shall not, and therefore doesn't apply to states. As a matter of fact, as Marshall says in Barron versus Baltimore, right, you're a dual citizen, right, and therefore it doesn't apply. And it's a similar kind of portion there.
Similar kind of argument.
But before we get to that, Ken, though, we're going to have to pause for just a second, because this is the end of our ad-supported preview. Normally, this is where we would stop our ad-supported preview. But this week only, we're doing something a little unique, and we're giving you this episode in its entirety, not behind a paywall. So listen to the rest of this episode with myself and with Ken. I really hope you enjoy it. And if you do like it and you'd like to listen to the earlier episodes or the ones that we're going to be doing as we get away from the 14th Amendment, we'd love for you to become a supporter by heading to patreon.com/politics, guys. But for right now, I'm going to shut up and you're going to get back to me and Ken. So Ken, I'm so sorry that I had to interrupt you, but take us away on state action. We were just saying it's very kind of similar to, Congress won't. And now we recognize, well, the Supreme Court says, well, it says the state won't. Take us away.
Yeah, so the majority of the Supreme Court in the civil rights cases drew this very sharp, bright line between conduct by government officials and conduct in the private sector. And the court said that the Equal Protection Clause and the Due Process Clause and the Privilege and Immunities Clause only apply to government conduct, not to private sector conduct, and that also that therefore means that Congress also lacks the new enumerated power that Congress got in the 14th Amendment to pass legislation to enforce the 14th Amendment. That legislation also can only be directed against governments. It can't be directed against the private sector. So the Civil Rights Act of 1875 is struck down. There is a good dissent by Justice John Marshall Harlan from Kentucky and he later becomes even more famous when he's the lonely dissenter from Plessy versus Ferguson a decade later. Yeah, but in this case, he starts off his dissenting, and on that court, John Marshall Harlan had the distinction of being the only justice on the court who was Southern. He was from Kentucky, and the only justice on the court who, in fact, as a child at least, had owned slaves. Now, he'd been fairly young, but it was not him that owned the slaves. It was his family that owned the slaves. But he lived in a slave-owning household when he was a child. And Harlan had a much more kind of real world or pragmatic view of these issues. And Harlan, in the civil rights cases, based on ideas that he developed there, and then he later refined these even more in Plessy in his dissent there. He's a dissenter in both cases. Harlan doesn't accept the legitimacy of any state action doctrine. And he argues that the whole point of the 14th Amendment was to try to slowly but surely transform society into a more colorblind society, and that all of the badges and incidents of slavery need to be lifted and abolished, and that if you basically say that all private conduct can still be discriminatory, and that the law can't be used to push back against that, then you just never get past a kind of a society that's based on race and racial consciousness. So I think Harlan had this good dissent, but he got outvoted, and the court for many years after that, and really to this day, never really changed it. Ended up saying, yeah, but the 14th Amendment doesn't limit private conduct. Now, a few things that changed, and we should just remind the listeners, we talked about one of these things many shows ago, is that eventually in the 20th century, the Congress's power to regulate interstate commerce gets to be interpreted more and more robustly. And eventually by 1964, Congress can reenact substantially the same civil rights law that it tried to enact in 1875. And it's able to do it based on the idea that it's all just regulating interstate commerce. And that does get sustained on that theory in 1965 in the Heart of Atlanta case.
Which we also covered specifically.
We covered specifically, yeah. But back in the 19th century, we did not have a robust theory of the interstate commerce clause. It probably wouldn't have been able, Congress wouldn't have been able to use that to regulate local forms of commerce.
Well, we're still talking, again, to kind of tie it back, we're talking about the E. Wickard v. Filburn interpretation of the Commerce Clause, which means that there is a wide amount, probably an overwhelming amount of intrastate in the court's opinion. And so things like this would have undoubtedly been considered. I think a theater pre-Wickard would have undoubtedly, we have the cases.
Been considered intrastate.
And therefore, Congress would not have been able to do what we see in the Atlanta case 60s.
Right. Yeah, right. So back in the 1880s, when the civil rights cases came up, Congress was held not to be able to regulate private conduct under its 14th Amendment powers, and nobody even really raised whether it could do it under the commerce powers because it was regulating intrastate commerce. But later in the 1960s, the court does rely on the commerce power to sustain basically the same law, but it doesn't go back and revisit that old issue about the 14th Amendment state action doctrine. It just gets there through a different route. So the civil rights cases remains good law, and it does sort of stand as as really a limit both on the direct uses of the 14th Amendment and also even on the indirect uses, on Congress's ability to rely on the 14th Amendment to pass civil rights legislation. So I think, like, if anyone's listening right now, if they're at home or if they're in their cars and there's someone else there, you can turn to the person next to you and you can discriminate against them and you can deprive them of liberty without due process of law. You can do all those things. And although you might be violating some criminal statutes or some tort laws, you won't be violating the Constitution, right? You can all turn to your neighbor and deprive them of their rights and you without violating the Constitution.
I'm just picturing a lot of people turning to their spouses and being like, you specifically. I don't know. I don't know why. When you said in the car, all I could think of was like turning to my wife and just saying something, sarcastically mean. No.
Yeah, lock him in a cage, deprive him of liberty without due process. Yeah.
Now you said something there. I just want to pause just for a second because I recognize what you're talking about, like a civil or a tort. And in those cases, what that means for listeners is these are actions where you're asking another private person rectify you over an action. But that's That is completely separate from what we're talking about here, which is where we have criminal actions going forward.
Right. I mean, there can be a little bit of overlay of constitutional law into tort law, but by and large, tort law is state law that's made by state legislatures or in state courts, and so it doesn't really usually affect the Constitution one way or the other. But if you did, for instance, if you deprived someone of liberty without due process of law by locking them in a cage, even though you couldn't violate the 14th Amendment because you're not a state actor, there's this tort called false imprisonment, so you could be sued for false imprisonment for that. So some of that conduct would still be illegal, but it wouldn't be unconstitutional.
Interesting that you bring that up because, that actually happened recently. There has been a whole series of emergent cases dealing with individuals forcing people to do OnlyFans. In fact, forcing to imprison them on that front. But we'll pause on that. Let's get back to state doctrine.
Yikes. That's kind of terrifying. Yeah,
it is. So, it really is.
So one thing, and you mentioned the Shelley versus Kramer case, and let's jump ahead to that one now. Although maybe there's let's jump ahead to that one. I was thinking there's some other ones we could do.
Well, but, that's a unique one because in that case, that's a 1911 issue, right? And so you have property owners in St. Louis who had entered into, and this was common. You would have covenants so that you couldn't own certain kinds of individuals couldn't own homes in that neighborhood. And specifically here, it is both Black and Asian individuals. Although there continued to be informal things like that, even deeper into time. But we'll pause there. But in 1945, a Black family, the Shelleys in this case, they purchased a home in a neighborhood without knowing about that covenant. And a white neighbor sues to enforce the covenant and to prevent the Shelleys from then taking possession of the home. And so the court has to deal with this because in this case, is this a private action or is this a state action? And so what does the court get us to there, Ken?
Yeah, so they say, it's a little of each, but to the extent that a group of neighbors got together and recorded restrictive covenants on their deeds, and said, we all promise never to let any non-white person live in any of these houses. All of that turns out to be private action because the government's not involved in any of that. And if they would have all adhered to their agreements, there wouldn't have been much that the law could have done to break it up. But what ends up happening is even though all the houses have these restrictive covenants, as you mentioned, one of the homeowners decides to violate it and to go ahead and sell to an African-American family. And then all the neighbors, very nice neighbors, they all bring lawsuits, right? So they sue the Black family.
I thought Louis Kramer was the one who, I thought he was the only one who brought. Did they all bring a lawsuit?
I guess probably just Kramer. I'm exaggerating when I say that.
I really thought. I think he was the one. He got like really upset, as I understand it. And he's like, "No, you're not," and that's what leads to the
I think there was divided opinion in the community, and some people in the community were, happy enough to have a Black family move in, but plenty of people in the community, not only Kramer, were against it, because they all had these restrictive covenants on all their deeds, and they all purposely lived in a community like that, I guess. Although maybe the covenants went back a few decades, so maybe some of them.
Yeah, and again, that's kind of one of the things I was pointing out, that is it took a long time because in some cases it was not easy to remove those items from covenants, and people were not always aware of them, especially if you were white. Why would you even think about it?
Right.
Again, that doesn't make them good. I don't want to say that, but it was a deep issue in property owning America for a long time.
Yeah. And so Kramer goes to court and he tries to get the court to enforce the racially restrictive covenant that's on the deed. And I should point out that other kinds of restrictive covenants on deeds that are not racially restrictive routinely are enforced by courts. So I actually have one on my deed.
Please.
I've got in my neighborhood, there's a community swimming pool, and they wanted to make sure everybody in the neighborhood would actually pay a membership and join the swimming pool. So they put restrictive covenants on the deeds that say you're never allowed to build a swimming pool in your backyard. So I have that one on my deed. So my deed runs without the right to build a swimming pool in my backyard. And if I tried to do it, then my neighbors could sue and stop me from doing it because the neighbors can sue to enforce a restrictive covenant. So that's sort of the general background law that although race was probably the predominant use of them in early 20th century America, there's other uses of them that are not as sinister. And so like that swimming pool one.
Although
So
as kind of I'll give away my libertarianness, I did not look at if any neighborhoods were like those HOAs and they had restrictive covenants, I would said pass.
You're out of there.
I wanted to live where real people lived. And so in my neighborhood,
you can put a swimming pool in your yard. Yeah.
Well, if we had that much money, anybody in my neighborhood would, but there's no rules against it anyway.
Yeah.
But no, continue.
So Kramer goes to court, and again, the background law basically being that unless it's unconstitutional, normally courts would enforce restrictive covenants like that on deeds of property if a lawsuit is brought by a neighbor. So the Shelleys argue, well, that's unconstitutional, and Kramer, because it discriminates based on race, right. but Kramer says, no, private. Because I'm not the state. Yeah, I'm a private person. So I'm one private person suing another private person. Neither of us is the state. So under this state action doctrine, the Equal Protection Clause shouldn't apply. But the court in Shelley versus Kramer looks at this through a more practical lens. And the court says, well, it might be true that you, Kramer, are not the state and that the Shelleys are not the state, but you're right here in a court. The court is a instrumentality of the state, and if you get a judgment from this court, what are you going to do with that? You're probably going to get the sheriff or the marshal or somebody like that to try to enforce the judgment. To go over there and put these people out of their houses, and he would be a state official, and he would be exercising the power that's vested in him by the state to evict people. So the court looks at all that and says, it might be private action and not state action, up to the point where people are putting covenants in deeds and agreeing with each other and abiding by that and sticking together on that. But once somebody comes running into court trying to get the court to help them enforce something like that, the court is a state actor. The sheriff is a state actor. The marshal is a state actor. So any effort to use the litigation system in this country to involve the litigation system, the court system or the law enforcement system in enforcing a racially restrictive covenant or really doing anything that discriminates based on race would be state action. And so the Shelley versus Kramer court says the racially restrictive covenant could be enforced privately by the private neighbors, but can't be enforced by a court, a sheriff, a marshal, anybody like that. That's where the state action line is drawn.
But that kind of leads to a big question, though, right, Ken? Because then, here's a state action, but the court in Kramer doesn't really then define what the actual limit state action is, and so federal courts have to start trying to apply criteria on almost a case by case basis to say, okay, what's the edge of this? And there's major doctrines that emerge. You get the public function test, the joint action test, the nexus test, and the state compulsion test. But it's funny, listeners. I saw Ken. He was really happy with me because I did that off the top of my head, and he was like, "Yes, I wish a student would do that too."
Yeah.
But it's not quite like some other cases where we have kind of a definitive case where we get the complete contours, which it makes it unique, right?
Well, I don't know if that's unique, but it's there are some other areas of con law like that too, but the court just can't come up with one big test. They just keep saying, well, we got different tests for different problems. And
so take us through these tests or take us through the cases that kind of take us on that journey.
The public function one is one of the first ones that comes up, but that's actually, I'd say, more of an exception than a test because unlike the other three that you named, the public function is one where the court ultimately concludes that it is going to treat a private actor as if it was a state actor.
Is that Jackson versus Metropolitan?
This episode is brought to you by Etsy.
Oh.
Hear that?
Okay. Thank you.
Etsy knows these aren't the sounds of holiday gifting. Well, not the ones you're hoping for. You want squeals of delight. Happy tears.
How did you?
And spontaneously written songs of joy.
I am so happy. Oh yeah, oh yeah, oh yeah.
Okay, the song needs a bit of work, but anyway, to get those reactions, make sure everyone on your list feels heard with handmade, handpicked, and designed gifts from small shops on Etsy. Gifts like personalized jewelry, custom artwork, cozy style items, vintage pieces, and home decor to celebrate all of your favorite people and their specific kind of special. For original gifts that say, I get you, Etsy has it.
Ford Pro FinSimple offers flexible financing solutions for all kinds of businesses, whether you're an electrician or run an organic farm. Because we know that your business demands financing that works when you need it, like when your landscaping company lands a new account. Wherever you see your business headed, Ford Pro FinSimple can help you pursue it with financing solutions today. Get started at fordpro.com/financing.
Is that the one you're thinking of there?
No. Jackson versus Metropolitan. That's actually different. That's about a public utility company, an electric company. But the big state action case involves the. I gotta look at I'm the spacing on the name of it momentarily.
Listen, you were not the first of us to. Listen, I have notes here too, just so everybody recognizes when we do these shows, we are definitely going from notes, at least on my side. I will say though, Ken, it is incredible how often I'm just because this is it's a podcast. I want listeners to know. I don't know how he does it because we've done this show in person once, and we did this, and he sits back, and it's like there's a computer in the back of Ken's brain, and he dials it up, and I can see it in his eyes, and then all of a sudden it comes out. I wish I had that. But I don't. So
when I was younger, I never forgot the name of any of these cases, but my neurons are not all firing as fast now. But it was Marsh versus
the whole
Alabama.
Time this whole series, I think this is the first time you said 1 second. Let me look up a case.
So Marsh versus Alabama is the case I was thinking of. Marsh versus Alabama, and I remembered that it was about the town of Chickasha, Alabama. And the thing about Chickasha, Alabama, is that it was an entirely company-owned town. It was owned by the Gulf Shipbuilding Company. So every single thing in that town was private property. All of the Gulf Shipbuilding employees lived in housing that was owned by the Gulf Shipbuilding Company. The only police force there was the security officers of the Gulf Shipbuilding Company. There was a school there that the employees' kids went to, and it was a private school run by the Gulf Shipbuilding Company. They had their own little fire department. So that kind of thing used to be a little more common in the country. In Kentucky, there were a lot of coal camps which were like that, where the coal companies brought all the coal miners out there and owned all the housing and ran a school and everything.
Yeah. There were even some songs about it, as a matter of fact.
Yeah. And I know you grew up in Kentucky, so you know about that. So Gulf Shipbuilding Company was one of those places. So, but if you actually went there, you wouldn't necessarily know that. This is way before the era of like gated communities and security compounds. These are poor people living there anyhow, so nobody's going to bother putting up a gated community and a security compound. And so pretty much anyone could have wandered into Chickasha, Alabama. The workers who lived there, had friends and relatives who would come over to their houses and stuff, just like anyone else. There were stores there that I think took company script, but if you wanted to pay U.S. cash, you could also spend that there, so people could go shopping in those stores. And so it looked kind of like a normal town, but it was all private property. And what happened is that one religious group who gets in a lot of the great 20th century constitutional cases, the Jehovah's Witnesses, they come there and they want to go door to door proselytizing like they do. And so the Jehovah's Witnesses start knocking on doors and trying to talk to people. And soon enough, the security guards come along and say, this is all private property. You got to get out of here. And they're like, well, what do you mean private property? It just looks like regular sidewalks, regular streets. I don't see any no trespassing signs, and the guards explain to them, well, no, but it's all owned by the Gulf Shipbuilding Company. And, we let the people who live here have their friends come over, but we don't allow any soliciting from strangers, and you just got to get lost. And so they bring a First Amendment case, basically, and they say they've got freedom of speech and free exercise of religion, and they're being denied all that by not being allowed to proselytize there. And The First Amendment, as I think people might remember, because we talked about this a couple shows ago, that's been incorporated through the 14th Amendment to apply against the states. So they brought this First Amendment claim, but technically it's a 14th Amendment claim because it's a First Amendment incorporated through the 14th Amendment. And so, of course, Gulf Shipbuilding defends on the ground, well, we're a private company. We're not a state actor. The 14th Amendment doesn't apply against us. To the extent that it also incorporates the First Amendment, that also doesn't apply against us. None of it applies against us. We're a private actor. And so the court in the Marsh case creates what they call the public function exception. That's one of the exceptions you named. But they actually don't really say that Gulf Shipbuilding is the government. They kind of acknowledge that it's a private company and it's not the government. But they say if a private company runs a company town and substantially provides all the public functions that normally a local government would provide. They provide the streets, they provide the sanitation, they provide the water, they provide the public schools, they provide the police, they provide the fire protection, they provide kind of everything you'd expect a local municipal government to provide. Then they're going to be treated as if they were the state, even though they're not. So that's why I say it's really an exception. So the Jehovah's Witnesses win the case, but it's not because the Gulf Shipbuilding Company is the government, but it's because in Chickasha, Alabama, it walks and talks and quacks like the government. It took on all the public functions.
It's functionally the government in that
functionally
sense,
the government.
and therefore it has to abide by those kinds of 14th Amendment state action.
Yep. Functionally is the perfect way to put it because it fits that word, public function. So
well, that's actually
that exception, however,
that's not me.
That exception doesn't really expand, and in fact, in some ways, it contracts later because people do try to use it in other contexts. So there's a couple of cases, both called Prune Yard Shopping Center, but it comes up two different times, where the Prune Yard Shopping Center is a shopping mall in California. And, it substantially has replaced the commercial functions of the old town square. Most of the stores are out in the mall now. And it does some kind of, non-commercial functions as well. Like people who want to go in there and go walking around for exercise can go in at like 6 a.m. before the stores are open. And there's the police have an actual substation in there and things like that. So people try to argue that just the same way the Gulf Shipbuilding Company had to tolerate some First Amendment activity in their company town because they assumed all the public functions that a government would assume, that maybe the Prune Yard Shopping Mall should also have to, and that people should have a right to go in there and do political leafleting and things like that. But the court ends up rejecting that and kind of cutting off that line of cases and saying, well, shopping malls may have taken over all the commercial functions and maybe even some of the social functions of the old town square, but they certainly haven't taken on all the functions that you'd expect a municipal government to take on. They're not providing schools, they're not providing hospitals, they're not providing a fire department. They're not taking care of roads other than their own parking lot, and things like that. And so they say it needs to be more public functions than just one or two public functions for the public function exception to apply. So that sort of does cut off that line of development. Although interestingly, California, where that case comes from, the holding in that case is unpopular in California. People in California actually mostly supported the rights of people who wanted to engage in First Amendment activity in shopping malls. And California and New Jersey, after that, explicitly amend their constitutions to get rid of any state action doctrine and state constitutional law. And so in the end, the California shopping mall wins its state action case under the 14th Amendment at the U.S. Supreme Court. They win that battle, but they lose the war because the California Constitution gets amended to have no state action doctrine for California constitutional law. So there's a little bit of limited development there. Now, the other tests that you named, all of those actually really are tests, I think, rather than exceptions. But the
so the joint action, for example, right? One of the cases that I'm familiar with, I'm nearby it now, but I didn't know about it then. Sigmund versus Community Care, right, which actually happens in Tulsa, just down from where I am. You have an employee in Tulsa. He works for the city of Tulsa. He gets drug tested. He tests positive for marijuana, and then so they send him to this a private drug facility called Community Care. And at community care, it does in fact have, like, a big surprise. It's here in Oklahoma. It's got religious content to it. And he says, you can't make me do the religious content. And in that case, they say, well, look, the relationship between the state and the private is so close. Right? You've together in such a way that the private doesn't get to get out of it. Is that?
Yeah,
is that,
because the state ordered them to go to that private facility.
Absolutely, yes.
Yeah. Yeah, another case I like that's a little bit more complicated, harder, I suppose.
See, I'm always looking. Listen, I'm always looking for the undergraduate level of case, right?
Yeah.
It's the one where you can, it's the 5 minute, But continue. Tell us
Do you
the
know
complicated
the Wilmington? Burton versus Wilmington parking garage. Okay. So that's an interesting case. In Wilmington, Delaware, in the 50s. So this is before the 1964 Civil Rights Act, when Delaware was actually like what we call a border state. It was a southern state. It was a slave state. Not by the 50s, but it had that culture. And so in the 50s, a lot of stuff in Delaware was still segregated, and and it wasn't necessarily illegal yet for private businesses to be segregated, because that didn't happen until the Civil Rights Act of 1964. So in the Wilmington parking garage case, the city of Wilmington had a city-owned parking garage, and it was open to the general public, and people who drove downtown, could drive in there and pay $1 or $2 and park their car, and it was owned by the government. And in that building, mostly the whole building was a parking garage, except that at the street level, the building had storefronts. And the government, which owned the building, leased the storefronts out to private tenants. And so one of the tenants was this coffee shop called the Eagle Coffee Shop, which was a privately owned private business.
I think we talked about this one earlier
before?
in the podcast, because I'm remembering the facts and I'm thinking, I never read these facts. Yeah,
I told you about it. I love this case.
Yes.
So it's a tenant. The tenant in the government building is a private business, and they will not serve food to African Americans. So it's a racially segregated private coffee shop in a government parking garage building, and they pay their rent check every month to their landlord, which is the city of Wilmington. So the case comes up, is this state action or not? And of course, the coffee shop says, I'm not the government. I'm a private coffee shop, and the plaintiff says, you're in a government building. They're the government, and so the court has to figure that out. And the court doesn't come up with a simple test. And so I was thinking of some of the tests that you were naming. They all kind of come into this. The court says, it's not as simple as just saying that everybody in a government building is the government, or that nobody in a government building, that no private party is ever the government, even if they're in a government building. We have to look at factors like, does the government have a close enough relation to this place? And you talked about the close relation. I think you used a different word, but basically the close relation test. Do they have a close enough relation that everyone in the government who works for the city, who works in this building, would of course have to know that this is a racially segregated coffee shop? Do members of the general public who observe that there's a racially segregated coffee shop in the storefront of a government building, would they attribute that to the government? Would they look at that and say, the government must not have a problem with having a racially segregated coffee shop in the building? Or would they not think about the fact that it's a government building and therefore not attribute it to the government? How easy or hard would it be for the government to monitor and prevent this kind of race discrimination from taking place in a partner's business? And so the court sort of asks all those kind of questions, which could come out differently in different cases. But in this case, they end up saying, well, it would be super easy for the government to realize that this is a racially segregated coffee shop because all these government workers go to work in the same building and they see it. It would also be super easy for the government to just put in as a lease condition for its tenants. If you want to be a tenant in a government building, you can't discriminate based on race. That would be pretty easy for them to do. And they conclude that that this is a city where there was a history of de jure discrimination. It wasn't that old. And so in that context, people seeing that the government is still running this segregated coffee shop, or at least allowing it in its building, even if it's not running it, that sort of does signify that the Wilmington City Fathers or the Wilmington City government just don't really have that. They don't care that much, or they're not bothered by it. And so the court says, all of those things make them conclude that that's enough of a relationship between the public partner and the private partner there, that the state act. It's the government that's the state actor, but that the state inaction of not forcing their tenant to become to serve Black people is enough to count as state action there.
Well, so Ken, what left do we need to think about in terms of state doctrine with our last couple of minutes?
Yeah, well, there's a few ways that doctrine doesn't get extended to other situations. You mentioned the Jackson versus Metropolitan Edison case. That's an interesting one. We sometimes hear the word public utilities. That's a phrase that people use when they talk about electric companies or gas companies or phone companies.
Probably in large part, in all honesty, just linguistically, because of things like the game Monopoly.
The game Monopoly? Yeah, maybe. Yeah, so we have that word utility. Yeah. Well, that utilities, but public utilities in particular, somewhat conveys the idea that they're public, that there's something governmental about them. But usually those kind of companies are actually privately owned. The electric companies. Yeah.
Always are. But they
Almost
live in a
are.
weird space that we end up calling quasi-public, which also is
quasi-public. That's right.
Often used for parties as well.
Yeah, and in the old days, before we had as much competition, the old regulatory model for most of those public utilities was that they were monopolies. They were granted monopoly franchises by the government, and they were closely regulated by the government. So they were in a kind of close relationship with the government.
Indeed. So it's upon a time.
Yeah, and Metropolitan Edison was one of those. They were just an electric utility company, and they were the only electric utility company in town. If you wanted electricity in that town, I can't remember which town it was, but if you wanted electricity in that town, you had to get it from Metropolitan Edison. Well, anyhow, the issue in that case is almost funny. The facts are almost funny. I mean, there's a guy who has electricity, and he just won't pay his bills, and they keep sending him letters and saying, "Look, we're going to cut you off if you don't pay your bills," and he just keeps ignoring that, and then eventually one day they cut him off. Well, then he brings a big constitutional case to the Supreme Court, and he says, they deprived me of property without due process. I didn't even get a hearing, when before they cut off my power. And the court has to think. I mean, they probably wouldn't have, found that there really was a deprivation without due process, but they had to figure out whether that even applied. Is there any obligation of a public utility to give people due process before they cut off somebody's power? And the court concludes that even though we call them a public utility, and even though they're in a close symbiotic relationship with a government regulator, because they have been given a monopoly and their rates are regulated and their terms and conditions of service are regulated, nonetheless they're private companies, and so they're not state actors. And and actually the same kind of thing happens. There's another case called Flag Brothers where there's this thing called a mechanics lien, which some of our less well-off listeners might know about. If you take your car to a mechanic and ask them to do work, and then don't pay the bill, and then go show up and say, I don't have any money to pay the bill, but I want my car back. They're allowed to just keep the car until you pay the bill, and that's called the mechanics lien. And that similarly raised questions about, well, if there's a state law called a mechanics lien that authorizes the mechanic to keep someone else's car, then is the state somehow involved in depriving the title owner of the car of their property in the car without due process, because there's no due process, right? So that's another kind of small bore kind of thing where this comes up. But again, the court did not find, they found that the single statutory right that the mechanic had to have a mechanics lien did not transform that mechanic into a state actor. He's still a private mechanic. And you get the same thing. There's some liquor license cases too. There were various private clubs that needed liquor licenses to serve alcohol. They had liquor licenses, but some of these private clubs would discriminate based on race. And so the same thing came up again. The fact that they have a liquor license, does that make them a state actor? But the court always kind of cut that off and was just like, no, it needs to be more involvement, like in the Wilmington Parking Garage case.
I hear it. Well, Ken, I think with that, we should probably bring the 14th Amendment to a close, and we'll have to start moseying on to the next amendment. It's been 3 cycles now on the 14th Amendment. So we'll have to move forward. The 15th, 16th
Amendment.
Yeah, because we got some of the fun suffrage cases coming forward next, and we'll have a number of those. It'll be a lot of fun. So if you've enjoyed this, obviously, if you're all the way to this point, that means you are already a supporter of the Politics Guys. I'm not going to try to sell you on becoming a supporter of the Politics Guys, but what I will do is say thank you so much for being a supporter of the Politics Guys. And I'll also say that we have had so many new individuals join us on Discord who said, oh, I've gotten this, but I'm finally going to do it. It's been a lot of fun. And so I hope that if you haven't, you should double check. Go to patreon.com/politicsguys. Not that I'm asking for anything else other than make sure that you're getting everything that you should be getting, right? And if you have access to the Discord group, come join us. I would love to be chatting with you on there. And if Ken did Discord, he would talk with you too. But I'll be there and I talk for Ken. I'm kind of like the sneak.
Every now and again, I get on there. I know it's not a regular habit of mine, but with winter break coming up, Trey, I'll have more time on my hands. Maybe I'll get on there once or twice.
See, that wasn't exactly a promise, but I'll take it. But in the meantime, I'll be this, I'll be the one that speaks for the Ken or something. I don't know, but I will suggest that you do that. I do hope that you already know that you can reach out to us on X and Facebook. You can obviously reach out to us on Discord, and of course, always at mail@politicsguys. And then again, don't forget, if you've really liked what Ken and I've been doing with these episodes, this is the kind of stuff to share with others and say, hey, wouldn't you like to get more of this? And if you're just now joining, don't forget you can come back through Patreon. Just go back, take a look. I think some of our best shows have been the Constitution shows that we've done, and those are always there and available for you. So again, head to patreon.com/politicsguys to make sure you're getting access to all of that. So with that, I want to say thank you to everybody, and a special thank you, of course, to the executive producers of the Politics Guys, who are Bruce Johnson, Wilma Marino, Daniel Toe, Ryan Beasley, and Don Oglesby. We'll be back upcoming weekend with another full-length show. I hope you'll join us then.
This podcast is part of the Democracy Group.